Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Today we are going to discuss the topic ex parte decree in the CPC. You are well aware, Order 9, Rule 6 deals with the so-called ex parte decree. You may be knowing this is under the head of appearance and non-appearance of the parties. So you file a civil suit or you institute a civil suit, maybe under section 26 of the CPC and read with 151 CPC. At the same time, under Order 7, you will file the plaint. The pleadings will be there as envisaged under Order 6, is it not? Then the defendant will be served with a duplicate copy of the plaintiff and he has to submit his written statement. After submitting his statement, normally some date will be given for the appearance of the parties. So in that connection, if the defendant fails to appear and in that connection, if the plaintiff is only appearing, please remember, when the plaintiff appears, of course you may be appearing through personally, through advocate or through your agent also. If you fail to appear, what happens? So if the plaintiff is disappearing or he has not appeared, the suit will be dismissed, no problem. Then if the defendant against whom the case has been instituted, if he fails to attend after serving the summons, please remember, after being served with the summons, if he fails to attend, the decree will be given against him. This is what is called ex parte decree, means in the absence of the party. The decree given in the absence of the party is called ex parte decree. So, please remember, this is neither void nor null, or it is null and not null and void. It is voidable. That means if you are able to show the sufficient cause, sufficient reason, it can be reopened. Please remember. This was stated in the famous case of Chandulal Agarwala. Chandulal Agarwala versus Khalilur Rahman, 1949 itself. So only thing is, if having been served with the summons duly, if you are absent, definitely a decree will be given against you. Then what are the remedies? If you go to Rule 13, yes, definitely you will find the remedies also. So if you are able to, if the defendant against whom the ex parte decree has been passed, if he files an application under Rule 13 to set aside the ex parte decree, it may be allowed, provided if you are able to show the sufficient cause. What is the sufficient cause? So please remember, normally we say that the summons are not properly served, or we say that Order Rule 6, the summons are not properly served, duly served we can say. So normally that will be one of the sufficient ground. Even though the word sufficient ground has not been defined anywhere in the code, it is a question to be determined by the facts and circumstances of the cause, of the case by the court. Please remember. So normally it should be the courts, they have got the instructions that sufficient cause must be liberally interpreted. So they should not be so rigid. It should be liberally. In case of Shyam Dasani versus Central Bank of India Limited, 1959. This case is also important case. Now I will tell you the remedies. Suppose if somebody files a suit and if you are even after filing the written statement you are absent, then the case is decreed against you, that is ex parte decree. Now what to do? What are the remedies? That also we should know, is it not? So there are 4 types of remedies. First one, already I told you, Order 9, Rule 13, that is to apply to the court. To whom? The court which passed the decree. Please remember, you need not go and file in the appellate court. The court, you have to file a petition in the court which has given the decree to set aside basing on the sufficient cause. You must show the sufficient reason, due reason, sufficient cause. Order 9, Rule 13. Then second, to prefer an appeal. So if the judge does not hear, yes, definitely you can go and file an appeal under section 96 clause 2. Section 96 clause 2, or to file a revision also, I think 115, section 115 also you can go for a revision. Please remember, if no appeal lies, otherwise you have to go for appeal. Then you can go for a review also. So you can request the courts once again, Your Honor, already I have stated like this, but you have not considered. So Order 47, you can go for review. And please remember, if the ex parte decree has been obtained by fraud. Yes, definitely you can file a suit on the ground of fraud. This was stated in Roop Chand Gupta versus Raghuram C. Private Limited, 1964 also. So normally there are certain people who say that even though summons are served, the defendant did not come, Your Honor, then the court may get annoyed and issue a decree also. If the decree is obtained by fraud, yes, you can file a suit on that ground also. So these are the remedies. Friends, remember briefly, this is the ex parte and setting aside the ex parte order also. Please read this topic thoroughly and then only you will be benefited. Otherwise, this much of speed you may not be able to grasp. So study the material, then you will grasp it very perfectly. Thank you very much.